Good afternoon. Javier Becerra, Attorney General here for the state of California. I want to thank the people who are with me, and I'm going to introduce them very quickly because they may have some things to add to the remarks I make today. Sam Siegel, who is the Deputy Solicitor General here at the California Department of Justice. Kathleen Borgers, who is a Supervising Deputy Attorney General who deals with a lot of these healthcare issues, in this case in particular. And Melanie Fontes Rayner, who is the Special Assistant to the Attorney General, especially when it comes to the issues of healthcare. The three of them are here, can answer questions as well about today's ruling that we're going to speak about today. I'd like to begin by giving everyone a reminder. The reminder is that if you are looking to sign up for health care here in California under the Covered California program, the Affordable Care Act program here in the state of California, do it. Open enrollment is still available to you until this Friday. Please take advantage if you want to be able to get coverage, healthcare coverage for yourself and for your family members. And I should also say, if you don't have health care and you haven't been thinking seriously about signing up for a plan under the Covered California program, reconsider. You still have a couple of days. You can go to Covered California, that's COVERCA.com, coveredcalifornia.com, to sign up. Today, the Fifth Circuit Court of Appeals, based in Texas, issued its ruling regarding the Affordable Care Act. I believe it's a regrettable decision that was issued, not because the ruling by the Fifth Circuit undid the entire Affordable Care Act, but because it leaves us today in a state of great uncertainty. Two of the judges, of the three judges who ruled in this appellate case, held that the individual mandate, which is part of the Affordable Care Act, is unconstitutional. One of the three judges disagreed vigorously. But today, not one of the three judges agreed with the district court in Texas that the entire law should be overturned. Not one. But then again, their decision, a 2-to-1 decision, has created real and long-term uncertainty for all Americans, but certainly those who use the essential benefits of the Affordable Care Act to cover themselves and their family, whether it is their children under the age of 26, whether you're a senior who receives Medicare, enhanced Medicare benefits, whether you're someone who now has received expanded Medicaid coverage through your state, whether you are someone who has been able to afford your prescription drugs under Medicare as a result of the expanded benefits. So many different ways that people have been able to take advantage of the Affordable Care Act. You can still apply today in California, but long term, I think you have to say, where we head is unclear. And as dissenting Judge Carolyn King said in her opinion, there is, quote, no reason to prolong the uncertainty this litigation has caused to the future of this significant statute, the Affordable Care Act. We mightily agree with Judge King's language and her words. It is for this reason that today we are announcing here at the California Department of Justice that we are prepared to file a cert petition with the U.S. Supreme Court to challenge this ruling, to uphold the Affordable Care Act in all respects, and to continue to protect the health care that millions of Americans have received and rely on in order to stay healthy and ensure that their families can move forward knowing that they are safe. Today's decision could take us to a dangerous and irresponsible place, not just for the 133 million Americans who right now have a pre-existing condition and could lose the protections against discrimination by health insurance companies when it comes to whether or not they'll qualify for a health care plan, not just for the seniors who use Medicare and now have access to zero copay preventative health care services and have additional assistance to pay for their prescription medication as a result of the Affordable Care Act, but for millions of children under the age of 26, like some of my daughters who currently have health insurance because their parents can keep them on their policies until they turn 26. Or perhaps it's those 20 million Americans who had no health care coverage before and now have it because they got their plan through the exchanges provided through the Affordable Care Act. Either way, today's decision could be a danger for them, and it's certainly irresponsible for all of us as a nation to see that we may be going down this treacherous path. For now, at least, President Trump got his gift that he wanted: uncertainty in the healthcare market and a pathway to repeal of the Affordable Care Act. And as a result, the healthcare that seniors, workers, and families they secured under the Affordable Care Act might be yanked from under them. So close to the holidays, our nation may have just taken a giant step backwards. But that's why California and our coalition of states, along with members in the House of Representatives, have been fighting to protect your health care every step of the way. We will move swiftly to challenge this decision and seek certification, because this could mean the difference between life and death for so many Americans and their families.